Hello and welcome to today's analysis. Today I'm discussing the making of a will, the issues of law surrounding the making of a will. I'm sure you've been hearing about, families talking about the will of their deceased father, the will of the deceased mother, their deceased uncle, and all that. Will is very familiar to everyone in our society. So I'm discussing the issues of law. And let me say this, it is important for you to consider writing a will. You don't need to be an old man before you write a will. For as long as you've started acquiring property, there is need for you to also consider writing a will to be able to settle your estates. So we go down to the issues of law surrounding the writing of will. Who can write a will and a lot of other questions. That is the essence of this video. So what is a will? A will is a written document showing how the owner of property shared his estates to his beneficiaries while he was alive. That for me is a very simple definition of a will, which is different from the other legal jargons about what a will means. So it simply means an expression of my intention in writing about how I want my estate to be shared when I am no more. So that's the simple definition of a will. Now, when does a will become effective? Right? When does a will become effective? The answer is simple. It becomes effective upon the death of the maker. So, while the maker of the will is still alive, the will does not take effect. In law, it is often said that a will is ambulatory. You remember the ambulance begins to blow after someone has been, moved into the ambulance. Maybe a dead man has been moved into the ambulance. The ambulance now begins to blow, 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 so that you give way for the corpse to be taken for interment, right? So a will is said to be ambulatory. That means it begins to have effects. It has effect in law upon the demise of the maker of the will. So if your father has written a will to your knowledge, and your father is still alive, your father lives for 90 years, 100 years, and continues to live, the will of your father does not become effective until your father dies. So that answers the question, when does a will become effective? The next question is, who can make a will, right? Who can make a will? The answer is, only a person who has a property can make a will. So you cannot will what does not belong to you. You cannot even try it because it will not be valid in law. You must have property before you can will. Now, you cannot donate what you do not have. It's just like saying you cannot place something on nothing and expect it to stand. So it is only someone who has acquired property, or someone who had inherited property from another, or someone who had been given a property outright that can donate the property to another through the instrumentality of a will. The next question is, at what age can someone make a will? At what age? The age of majority in Nigeria is 18. So once you are 18 years of age and you have property, the law allows you to donate your property in your will. So 18 and above, you have the legal competence and capacity to donate your property in a will. So you can make a will from 18 and above. Note, however, that for those that are in the military, the Army, the Navy, the Air Force, and other, military formations and outfits. Those ones, their lives are endangered every day. They're in the battlefield, they're in the sea, they're flying and all that, working for their nations, and therefore the law allows such persons to make a will at the age of 16. So for those that are in the military, they can make their will at the age of 16 and that will be valid. But for those that are not in the military, if you make your will before the age of before the age of 18, that will is not going to be acceptable to the law because the law will imply that you do not have the capacity to have made a will. Now, the other question is it compulsory to register a will in courts? Some persons just write wills and then they keep the will in their homes. They don't go and register the will. The answer is, for the will to be recognized by law, you must register it in the probate division of the court. When you go to the high court, there is a particular segment of the high court that is known as the probate division, probate court, right? There is a judge that sits in that court. In some states of the federation, you have a magistrate that is serving as the registrar of the probate courts, right? So the duty of that registrar is to take care of probate matters, application for letters of administration, registration of will, for will number to be given, and so on. So for your will to have legal um, um, recognition, you must not just write your will and put it in your briefcase. No, it's going to be challenged. So you must write and then ensure that you take the will to the probate division of the High Court and have it registered. The probate division of the High Court is usually at the headquarters of the state High Court. So whatever state of the federation that you are in, the headquarters of the state High Court, you certainly have the probate division there. Ensure that you register your will. If you want that will to be recognized by law, register it. When it is registered, it is sealed up in multiple envelopes, sealed up to the extent that you cannot open it, okay, before the person that deposited the will dies. While the person, you cannot just open it like that. It's sealed up. And what you should insist also is that it should be given a will number. You should have a will number. Every will that is registered in the probate section is given a will number. Get that will number, because that is what identifies your will and differentiates it from every other will. I've often said, when you get the will number, let your family members know that you have a will and that this is the number. It doesn't allow them to go and read the will and have the will opened or so on. For me, you should let the family know that you have a will number, shared with them, so that when you pass, they can go to the probate division of the court and then have the will read. There is another question, and that question is, after I have written my will, can I amend my will? Okay, so let me give an explanation. Someone has 10 houses. In 2024, he has written his will. He has shared the 10 houses to his 5 children. And in 2025, the man acquires 2 additional properties. Okay? That means his estate has increased, has expanded. The law allows that man to amend his will so as to include the additional property that he has acquired. That is known as codicil, additional will. So you can either withdraw the one that you have already registered, okay, cancel that one, write a fresh one, and include the new property, or you have additional will, which is usually called codicil in law. And when you take the additional will or you make a fresh will, you capture everything. So at any time whatsoever, while you are still alive, you have the right to amend your will, to incorporate new things that you have brought um, into the will. Now, there is another question. Can someone make a will for another? Can someone make a will? Oh, I love this, my son, so much, and I want to make a will for him. I want to write his will for him and partition his estate so that when he dies, you know, the beneficiaries will take it. Oh, I love my brother so much, and I'm more educated than him. I want to make a will for him. The answer is no, you cannot make a will for someone. A will is the voluntary action of the owner of property. And you do not have the right in law to make a will for your friend, for your brother, for your sister, for your son, for your siblings, and so on. Allow the owner of property to make his own will and let him do it by himself. The other question is there any kind of property that cannot be willed? Is there any particular kind of property that cannot be willed? Right? The answer is that every property can be willed. Every property can be willed. land, cars, houses, shares in listed companies, money, retirement benefits, every item of value can be willed, provided you are the owner of that property. You can will it to anybody, you can will it to a church, you can will it to your mosque, you can will it to any charitable organization, you can give it to your family members, to your friends, to a domestic servant who has served you for many years meritoriously, and you just feel you should give a fraction of your estate to that staff, to that domestic servant. The law allows you the prerogative as the owner of property to give your will to anybody that you so desire to give. So the answer is every property of value, anything of value, can be willed out to the beneficiaries of your estate. And no one can choose beneficiaries for you. You have the right to choose who to benefit from your estate. That is the right that is exclusively um, within the purview of the owner of the estate. Now, there is a serious question here, which a lot of people ask this question. And the question is, can a man exclude a stubborn child from his will? Can a man exclude a stubborn child from his will? The answer is yes. The law allows you to exclude anyone from your will. So there are instances where some children have given so much headache to their parents, and for that reason, the parents decide to make the will and then exclude them. Some sons or some daughters, they don't want to do anything in their lifetime. They don't want to work. They don't want to be productive because they know that their parents have, very reasonable size of estate, and that when the parents die, they will be the beneficiaries of the estate. And for that reason, they begin to give so much trouble to their parents, and their parents have suffered so much stress in their hands. And the parents can decide to say, for your unacceptable conduct during my lifetime, I'm not going to reward you with any item in my estate. And therefore, the owner of a property has the right to exclude anybody. So the wife can exclude the husband from her will. The husband can also exclude the wife from his will. The man, the father, can exclude a son from the will, can exclude a daughter, can exclude a brother, can exclude anybody that he chooses to exclude from the will. Why? Because a will is a written document which you voluntarily write, partitioning your estate, giving instruction on how your estate is to be enjoyed upon your demise. It's voluntary, and therefore you have the right to include anybody. You also have the right to exclude anybody. Now, this is a very important aspect of today's conversation. What are the ingredients of a valid will? And it is important that we discuss this because you can make a will, you can make your intention known, okay, and expect that it's going to be carried out when you pass on. But what you call a will does not pass through the test of law. It doesn't have the ingredients to make the will valid. And this is the reason that you must note these points very, very well to understand what the ingredients of a valid will is. You need to have it at the back of your mind while making your will. The first ingredient is that the person that is making a will must be a person of sound mind, right? That means that a lunatic cannot make a will. That means that a person that is mentally challenged cannot make a will that will be valid in law because the law considers it to be that that person does not have the capacity, the mental capacity to know who to give his property to and who not to give his property to. So the person must be a person of sound mind. Now, you also go to the hospital and you see people in the emergency unit, ICU or something, you know those names that are usually called in the hospitals, those that their health situation is critical and they can barely take care of themselves. They can barely walk to the convenience to take care of themselves there. They can barely eat. They are being fed through their noses, okay? They don't really know themselves at the point that they are there in the hospital. You see some family members trying to be funny to take documents to the man for the man to sign in the name of making a will. Here is the danger. That will stands the possibility of being challenged for reason that at the time of the purported making of the will, the man that is said to have made the will was not a person of sound mind. He did not have the mental and physical capacity to have made a will. He was critically ill. And for that reason, he could not even take care of himself. And for that reason, the law would assume that he did not have the soundness of the mind to have made a will at the time that the will is said to have been purportedly made. The second ingredient is that the will must be signed and witnessed by at least two persons. So in law, it is often said that an unsigned document in law is a useless document. Okay? So someone has written so in a document and then he fails to sign. When it is tested in law, an unsigned document is a document of no value. And therefore, that is why the law says that the maker of a will must ensure that he signs the will. If you don't sign your will not have any legal validity. And therefore, there's need for you to ensure that you sign your will after making the will. The law makes an additional requirement that the will must be signed in the presence of two persons, so witnesses. Okay? So you must, in addition to your signature, you must have two persons to witness the signing of your will. So maybe two friends of yours, maybe two elders that you respect. Okay? You take it to them. All of you sit together. You sign first, and then they sign as witnesses. Their names are there, the date of the signature, and possibly also the time of the signing of the will. The reason is that by the time you die and the will is to be read in court, the witnesses are usually expected to come and then talk to the court on oath that they witnessed the signing of the will. So if there is any challenge to the will, these witnesses are certainly going to be available to ensure that they attest to the authenticity of the will. So the second requirement is that the person must sign the will and must do so in the presence of two persons, not in the presence of one person. I tell you something. Whenever a will is to be challenged in court by lawyers, what lawyers basically look out for is if the ingredients of the will have been met. So when a lawyer sees that the will was not signed, that's a serious one that can lead to the setting aside of the will. When a lawyer sees that the will was not witnessed by at least two persons, it was witnessed by only one person, that means that that will does not meet the requirement of the law. The third requirement is that the will must have beneficiaries. The will, for it to be valid, must have beneficiaries. You cannot just make a will for nobody. So if a will is blank, if a will is such that it doesn't have beneficiaries, there is no way the law courts will give recognition to that will. It will even query the authenticity of the will. It will, for instance, query if the maker of the will was of sound mind at the time of the making of the will. Because making a will and having no beneficiary, makes it suspicious that the maker of the will was not in his right senses at the time of making the will. Because why are you even making a will if you do not have beneficiaries? So the third requirement is that the will must have beneficiaries. The fourth requirement is that the maker of the will must be of legal age. So if somebody is less than 18, the person cannot make a will that will be recognized by law. So he must be of legal age. If the person is less than 18 and the person is not in the military, is not in the Air Force, not in the in the Navy, that means that person did not have the capacity, and that will lead to the setting aside of the will. Now, it must be written. That's the number 5 requirement of a valid will. For a valid will, the will must be written. So if someone um, says he has made a will and the will cannot be shown in writing, it's not signed. If it is not in writing, it will not be signed. It will not be witnessed. And other ingredients will not follow. And therefore, your will must be in writing. If it is not in writing, it will not be recognized by law. So those are the 5 basic ingredients of a valid will. Now, there is another question. Can a woman make a will? Can a woman make a will? The answer is yes. Why not? A woman has property which she purchased in her name, maybe before marriage or in the course of marriage, and the property is in her name, or she inherited property from her deceased parents. She has a right in law to give her the property to anyone. Could be her children, could be her husband, it could be her family member, it could be a fraction to charitable organizations, could be to the church, to the mosque, or anything. But the answer is that a woman who has property in her name can donate that property in a will. So a woman can rightly make a will under the Nigerian law. The next question here is, can I write a will by myself? Can I write a will by myself? Or must I go to a lawyer to write a will for me? The answer is, you can write a will by yourself. You see all this discussion. Will, in the eyes of the law, you can write a will by yourself. You can write it, you can just type it. You can also do it handwritten. It is valid. However form you want your will to be. Is it in writing, handwritten, or is it typed? Provided it is written in readable form, that will is valid. And you can write it by yourself. Like I said, you don't need to get a lawyer to write a will for you. The law allows you to write it by yourself, take it to the probate section, register it, pay the necessary fees, which most times is very cheap, maybe 10,000, but less than 50,000, depending on the size of your estate. You deposit it, and then it is valid. You write it yourself. Maybe you're a learned person, a professor, a teacher, or anybody that can write and read and write. You have the right in law to write a will by yourself and take it for registration. It will be accepted. However, it is often advisable to get a legal practitioner to prepare the will for you. If you are writing the will by yourself, you may not be mindful of the ingredients of the will, of a valid will. It is for that reason that you are most times expected to go see a legal practitioner, a lawyer, to write a will for you. It can be any legal practitioner, a trusted legal practitioner. Even a lawyer that is working for government in the Ministry of Justice, for instance, nothing stops him from writing a will for you. A lawyer that is in private legal practice, he can write a will for you. All you need to do is to go to a lawyer that you trust and then entrust him with the items in your estate. Tell him how you want it shared, give him the formula, and then he does it for you, gets it registered, gives you the number, and then you keep the number for a time that you'll be called upon by the Almighty Creator. Now, let's look at what are the benefits of having a will. What are the benefits? Number one, it gives you an opportunity to choose who to benefit from you. While you're alive, there are some persons that maybe they never wished you well. Maybe they don't even greet you. Maybe they don't even wish you well. And perhaps you don't want them. I mean, we're humans. You ordinarily do not want them to be the beneficiaries of your estate. So what you do is that when you write a will, it gives you the opportunity to choose who to benefit from your estates. Number two benefit is that you can donate to charity. Gives you that opportunity to donate to charity, maybe to schools, okay? Maybe you donate your books to a faculty in a university through your will, and you donate a portion of your estate for the orphanage or any other charitable organization. The third benefit is that it protects your family from obnoxious customs. This is very important. It protects your family from obnoxious tradition and custom. There are some communities in Africa that their practices as regards inheritance can only be described as terrible. They say, for instance, women are not allowed to benefit from the estates of their deceased ones. For those that are allowed, they are given a small fraction. And all those cultural practices that are not, in sync with modernity. For that reason, when you write a will and you share your estates, you divide your estate to your female children and everybody that you want, and also divide to your wife, your will protects them from such obnoxious customs and practices that may be applicable in your community. Some persons want to be buried in a very special way, in a particular way. Some persons die in America, they want to be flown back to Africa and be buried. Some persons want to be buried in a particular location in their compounds. Some wherever. Some don't want to be buried in their compounds, they want to be buried in cemeteries and all that. Whatever you decide, a will gives you the opportunity to give funeral instruction to your beneficiaries. Now, number 5 is that it protects your estate from being contested. So it stops someone from coming to say, oh, this estate, this particular property was owned by me. Because already you have settled the property in your will. Number 6, it makes you avoid the costs and tedious process of obtaining letters of administration. For those that are watching this video, some of you must have applied for letters of administration. Some of you may not have been lucky enough to have the letters granted to you on time. So you have to wait for like 6 months, sometimes 3 months. Some persons have to travel all the way from abroad to come and prepare letters of administration here because their parents did not leave behind a will. So when you write your will, you settle all that. No need to go and get letters of administration anymore because you have already settled all that in your will. So it is very significant to write a will to be able to settle your estate. Now, my general advice is that it is good to have a will while you're alive. This is my last advice on this. It is good to have a will to be able to address your property while you're alive. It saves you a lot of stress. It saves your family a lot of stress when you have a will for them. It also exemplifies your love for them and stops obnoxious customs from prevailing over your estate because you have already settled your estate in a will. A will is a vital document that is recognized by law globally. The language of a will, the efficacy of a will is a global thing. And so when you deposit your will, everything is intact, it stands. No matter who you excluded, it will stand. No matter who you included, it will stand. And therefore, there is the need for everyone to consider, as you start to acquire property, consider having a will to be able to address all the issues the way you would have loved them to be addressed. Many thanks to all of you for watching this very episode of today's analysis. If you have your comments, drop your comments in the comment section. You want to know why a man would, exclude his child from a will. You want to know why a man would donate a certain portion of his estate to a certain number of people and all that. You also want to know more legal issues about the making of a will under the Nigerian legal system or any other legal system in Africa or globally. Drop your comments in the comment section so that together I can pick it up and then explain more as we progress in our analysis. Many thanks.